we're at about 56 minutes. We'll do one more question because this one's got a lot of information in it. So we'll go back to Bob again. Is 51%? So I think what he's asking is preponderance of the evidence enough to kick dad out of kids' lives for 10 years unless dad pays support and all mediated and supervised visits despite everything being at. So there's a lot there. So I want to kind of tame it down a little bit. So 51%, I'm assuming we're talking preponderance of the evidence. Mm-hmm. Unfortunately, I'll kind of take that piece of it. 49 of the 50 states, preponderance of the evidence is the burden of proof in family court. Arkansas, which passed their law last year, is the only state that has a clear and convincing evidence, which we would like to get passed in every state, but preponderance is enough. So when it comes to domestic violence, when they allege domestic violence, courts by preponderance of the evidence, much different than criminal court. If one feather falls on their side compared to yours, that's enough for them to make a finding that domestic violence occurred, that it's not in the best interest of the child for this to occur. So I'll kind of pass it to you to start this. So in terms of custody and visitation, or custody and parenting time and support, in the state of Indiana, is there any link to the two, or are they completely separate issues?
These are two separate issues. Just because a father is not paying child support does not eliminate his parenting time. Now, that issue is going to essentially be addressed in the court, trust and believe. But a mother cannot say and have standing to have an argument to say, well, I'm withholding the child because he hasn't paid child support, and he hasn't paid it in 10 years, Your Honor. Okay, is the judge going to be happy about hearing that? No, he's going to have arrears, and he's not probably going to be able to file the child on his income tax every other year. But those are two separate issues. So using that as a argument, or if the mother is trying to use that as an argument in the state of Indiana, it's not going to work because you cannot withhold the child just because father is not paying child support or behind in child support.
Yeah, I think that's dead on for all 50 states, is that custody, visitation, parenting time, whatever your state calls it, is a separate issue from child support. So like just like we hear stories of dads can be forced to pay child support but have no parenting time. If you don't pay it, there could be potential criminal. I mean, you're talking about contempt, garnishments, bank levies, that type of stuff. But it technically can't have an impact, and a judge should not be able to use that as a reasoning for severing your parenting time. There would have to be some other reason that they have found that it's in the best interest of the child to sever your parenting time. So once again, based on what you wrote, Bob, I would say that it's something you need to get in front of a judge. If you have parenting time, or it's been suspended for something that's been found to be unsubstantiated, you need to get back in front of a judge. And you have to understand she's probably going to file contempt, or the state's going to come after you for failure to pay child support. But that's not a reason for them to keep the children from you.